around, what it is, what it isn't, why it's important, and hopefully we'll have a little bit of fun too. I'll try to get through as quickly as possible so I can leave some time at the end for any questions people might wish to ask, and I can answer all questions. So here we are. You already have some of my background information. Lifetime competitive shooter. I played a modest role in the founding of IDPA. My number is 13. And I always feel obliged to put that in context, how modest the role is. So the first major IDPA match was the Columbia Invitational. It was the start of everything. At the end of the match, they had a big banquet. And Bill Wilson got up at the podium and started thanking all the people who contributed to getting IDPA off the ground. And as I said, I made a modest contribution. But what I didn't expect is he started calling people up to the podium and handing them boxes. And each box contained a Wilson combat pistol. And I thought to myself, oh my God. It's like you did a small favor for a car dealership and they gave you a Maserati and things. And I thought to myself, I'm like, I did so little really. There's no way he's going to call me up. And then he calls my name. And I walk up there and get up to the podium and he reaches behind me. And he hands me a $10 wall clock. It says thanks. Which was perfectly proportional to my contribution. But that's how modest it is. Master class shooter, or at least I was 10 years ago when I made master class. Actually, making master class was kind of a mixed blessing because I knew I was never going to win a match again. So I'm probably the least skilled master class shooter in the country. So really a highlight of my competitive career was the year before when I shot the New England Regional and I won first place for expert, the classification just below master class. And I've got this big plaque going to hang on my office wall. It's a big mold 4-color thing. It's beautiful with the IDPA logo. And I put the nail in the wall and I got the plaque and I noticed it got a little dusty. So I got some fantastic and I spritzed it and I wiped it with a cloth and all the ink came off. I still have it on my wall, but it doesn't say much. Okay, I'll skip through the rest of this. This is, of course, it's not for you guys. Whenever I give a seminar and I give these law self-defense seminars all over the country, I always have to tell people, this is not legal advice. I only practice law in Massachusetts, and even if we were in Massachusetts, it wouldn't be legal advice. And then I also have to tell them this. There's no attorney-client privilege. And I tell them this because you would not believe the stories people will tell you during the breaks that end with things like, so that's why I'm happy I own a backhoe. These are things I don't need to know nor want to know. Okay, self-defense. What is self-defense? Of course, self-defense is a physical act, but it's also a legal defense. It's a legal defense to the use of force that would be unlawful, but for circumstances that justify or excuse that use of force. And it's an affirmative defense, meaning that essentially what you're doing is you're saying, yes, I did that. I used that force. I shot that person. But I had legal justification for doing so. So you can imagine the consequences if it turns out your legal justification isn't so robust, right? You've effectively admitted to the underlying crime. So it's important to get it right. Now, self-defense conceptually consists of 5 distinct elements: innocence, evidence, proportionality, reasonableness, and avoidance. Avoidance, of course, being the key one for today's talk, because we're going to talk primarily about standing ground. Importantly, these are cumulative. They all have to be present. If the prosecution can disprove even one of these elements, then whatever your use of force was, it was not self-defense. One variance, of course, is Ohio. You always have to call out Ohio. In 49 states, once self-defense has been properly brought into court, the burden of proof is on the prosecution to disprove self-defense beyond a reasonable doubt. Except in Ohio, where the defendant retains the burden of proof to prove self-defense by a preponderance of the evidence. But in any case, the important point is to cumulative. All 5 elements have to exist or have to be excused in one fashion or another, or self-defense fails. So I'm going to go through the first 4 rather quickly and then try to get to avoidance to talk about standing ground. So the first principle is innocence. Obviously, self-defense is intended to benefit the law-abiding innocent person, not the aggressor. You can't be the aggressor and then justify your use of force as self-defense. It sounds obvious, but of course, people can get into trouble on the element of innocence. You have to keep in mind that it's not really so important whether or not you actually were the aggressor. We're telling stories in the courtroom, right? The prosecution is telling the story of guilt, and your defense is telling the story of innocence. What really matters is whether or not you can be made to appear as if you were the aggressor. And if you can, and there's a number of ways this can happen, witnesses can perceive that you might have been the aggressor, or maybe the other guy has his friends with him and they're going to testify that you started it, then you lose self-defense. Unless you can recover your innocence, there's ways to do that, but that's beyond the scope of what we're talking about today. The second element is imminence. Self-defense is intended to allow you to defend against an attack that's imminent. The best definition of imminence I've come across is this one from Black's Law Dictionary. I think it communicates it very well. An imminent danger is an immediate danger, such as must be instantly met, such as cannot be guarded against by calling for the assistance of others or the protection of the law. Such an appearance of threatened and impending injury as would put a reasonable and prudent person to his instant defense. So it's a threat of death or grave bodily harm that's about to happen right now. That's what we're talking about with respect to imminence. Proportionality, third element. The amount of force you can use in self-defense has to be proportional to the amount of force with which you're threatened. And really what we're talking about here for practical purposes is whether or not you can use your face with a non-deadly threat or a deadly threat. If you're faced only with a non-deadly threat, you can only use non-deadly force in self-defense. And you can use deadly force in self-defense only if you're presented with a deadly force attack. And in the context of self-defense law, anytime we use the phrase deadly force, what we're really talking about is a force capable of causing death or grave bodily harm. Maiming, loss of function of a body part, rape, things of that sort. The fourth element is reasonableness, although for some reason I have it listed as the fifth here. Ignore that, please. I just got my numbers out of sequence. Your conduct in self-defense must have been reasonable. And how the courts determine whether or not it was reasonable is to apply a two-part analysis. First, they look to see if it was objectively reasonable, the conduct of a reasonable and prudent person. And then they ascertain whether or not it was also subjectively reasonable. Now, the objective reasonableness, the reasonable and prudent person, RAP. You know, us lawyers in law school, we learn to love our acronyms, so there's acronyms all over the place. Think of the most responsible person you know, the kind of person you would want house-sitting in your home if you had to be called away on business. They're cautious, they're responsible, they're sober, they're slow to anger. And then the courts take this kind of hypothetical, reasonable, and prudent person, and they customize it for the particular circumstances of the self-defense case before them. So you end up with this customized, reasonable, and prudent person. So it's a reasonable and prudent person. Thanks to somebody for noticing. In the same or similar circumstances, with the same or similar capabilities, with the same or similar mental state. So again, customized for the particular circumstances of the self-defense scenario with which the court is asked to address. In terms of subjective reasonableness, in addition to the conduct being that of a reasonable and prudent person, you must also have actually been in fear. You must have believed it yourself. If you fail subjective reasonableness, you fail reasonableness. If you fail the element of reasonableness, self-defense goes away. But how do you get subjective evidence in front of the jury if you don't want to take the stand yourself? This is a common difficulty that self-defense defendants face. I suggest it might be an important role for your 911 call. To say right on the 911 call if you want to fear for your life. Obviously, you're going to call them. I hope you're going to be the person who calls them. And they're going to say, what's your emergency? And you're going to describe your emergency. As part of that description, you may as well say, I was attacked, I was in fear for my life, and then you've met your burden of production on that particular element. So how does the court actually know your subjective belief? If you didn't get it on the 911 call, well, they impute it, your state of mind from your own words and your own conduct. So in my seminars, we spend a lot of time talking about this because a lot of people get into trouble not so much from their actual conduct in defending themselves, but what happens in the immediate aftermath, things they do or things they say. I wrote the first edition of the book because it was common for people to tell me, well, if I have to shoot someone, I'll just drag them into the house. Maybe the shooting was perfectly lawful and defensible and justified, but once you drag that body into the house, now you've tampered with evidence, and that's consciousness guilt material. So. Okay, now to the fifth element, the the main one we're here to talk about today, avoidance. And this refers to a generalized legal duty to retreat. Meaning, if you have a safe avenue of retreat, you're not required to increase your jeopardy to meet this element. You must make use of it before you can resort to deadly force and self-defense. So before you can resort to deadly force. So the duty doesn't arise until it's a deadly force of confrontation. In fact, however, I call this the fifth element because it exists, but in fact, only 16 states impose this fifth element. So you may have heard around the Zimmerman case, a lot of people talking about this crazy stand your ground law that Florida has where you don't have to retreat. In fact, it's common that the duty to retreat is not imposed by states. The 16 that impose this fifth element of avoidance, they're the duty to retreat states, we call them. The majority, the 70% of states, 34, that do not impose a generalized duty to retreat, those are all effectively stand your ground states. So stand your ground is not something weird or unusual. It's the most common means of approaching this issue among the states. Now, it's important to realize that the only thing that stand your ground does is excuse that fifth element. The sole function of stand your ground is to relieve you of an otherwise existing duty to retreat. Period. That's all it does. And because the media does such a terrible job of covering this type of issue in these types of cases, it creates tremendous confusion. People think stand your ground does a lot more than what it really does, which is not much. It just removes the element. Stand your ground is not some weird parallel or alternative way of justifying the use of force. There's no such thing as claiming stand your ground as an alternative to claiming self-defense. It's not like it's another option on the table. There's no such thing in particular, and this is a pet peeve, as a stand your ground hearing. You hear all the time in Florida people defended themselves on the basis of stand your ground, or they had a stand your ground hearing and didn't have to go to trial. There's no such thing as a stand your ground hearing. Stand your ground merely eliminates excuses an element of self-defense. What they're talking about when they say that is a self-defense immunity hearing, which you can do in Florida. You go to court prior to your trial and you have a hearing with the judge, and if by a preponderance of the evidence you can demonstrate that you meet all the elements of self-defense, you'll be granted civil and criminal immunity. But that has to do with self-defense immunity, which is not stand your ground. Completely different legal doctrine. So to justify use of force in a stand your ground state, you don't claim stand your ground. You simply claim self-defense like you would everywhere else. Except instead of having 5 elements that you need to prove to uphold your self-defense claim, you just have 4 elements. And that's all stand your ground is, period. So even in a stand your ground state, all those first 4 elements apply. So if we know what stand your ground is, then we also know what it isn't. And it's important to know what it isn't because there's a lot of misinformation put out there for a variety of reasons. Sometimes it's just ignorance, and sometimes it's for political purposes. But what stand your ground is not, does stand your ground allow you to kill as an act of aggression? No, of course not. You still have to meet that first element of innocence in order for your self-defense claim to stand. Does stand your ground allow you to kill based on a speculative threat? No, you still have to be facing an imminent threat of death or grave bodily harm that's about to happen right now. Does stand your ground allow you to stop or merely to kill, to stop a merely non-deadly attack? No. You still have to use no more force than necessary to defend yourself. And does stand your ground allow you to kill based on an irrational fear? And this is a big one that's promulgated by the media all the time, saying that someone could merely be afraid of young black men, and then understand your ground that would justify them committing murder. Absolutely not. You still have to be acting reasonably, both subjectively and objectively. So, why is stand your ground important? In the 16 duty to retreat states, they're not satisfied if you meet just the 4 elements of self-defense. As far as they're concerned, even if you're wholly without fault in the fight, absolutely the innocent person in terms of how the conflict got started, even if you're facing a death with grave bodily harm right now, even if you use no more force than absolutely necessary, and even if your conduct was entirely reasonable, both subjectively and objectively, they still reserve the right to put you in jail for the rest of your life if you don't jump through one more hoop. You have to prove a negative. Oops, sorry about that. They insist you prove a negative. They insist you prove that there was no safe avenue of retreat. If you can't do that, you're done. Your self-defense claim fails. Excuse me. Now, opponents of Stand Your Ground like to characterize folks like me who support Stand Your Ground as people who celebrate death. I hear that quite frequently. They envision hordes of armed men, that's us, typically white men in their minds, lusting for an opportunity to gun someone down. And of course, in their minds, we're always gunning down young black men. Thus, in their view, Stand Your Ground is inherently racist. Of course, if you ever meet these people, and I meet them a lot, everything in their view is inherently racist. The entire world is institutional racism. Every person, every pet, every tree, every blade of grass, it's all racism. You can't avoid racism any more than you can avoid gravity. And when you hear them talk, sometimes it's like they have this weird progressive thesaurus in their head. Lots of big, complicated words that start coming out of their mouth. None of it actually makes any sense. It's more like mouth noises. And sometimes they start talking to me and my brain just kind of fuzzes out and says, blah, 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 social justice, blah, 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 racial sensitivity, blah, blah, blah. And then at the end, they stop talking and I realize they're done with that and I walk away. In fact, of course, what Stand Your Ground really is not a celebration of death at all. It's a celebration of life. And this is how I communicate Stand Your Ground. I say, look, we're not out to kill people because we support Stand Your Ground. I love life. I love my life. I love my wife's life, my children's life. I love the lives of my parents, my siblings, my friends, my colleagues, even all of you progressives, not you folks. Everyone in the room, I love life. In a perfect world, nobody would ever die in the world. But in the real world, murderers and rapists and assaulters exist. They're real. And their victims number in the hundreds of thousands every year. All Stand Your Ground says is that if you're wholly without fault in starting the fight, and you're facing the threat of death right now, and you use no more force than necessary, and your conduct was entirely reasonable throughout, both subjectively and objectively, that's enough. If you meet all those four conditions, you should be allowed to lawfully defend yourself against a lethal attack. In effect, Stand Your Ground is really just a legislative policy statement. It's a policy statement to prosecutors saying, hey, if you have a defendant who did everything perfectly in regard to self-defense, but for that last element, they can't prove a negative. They can't prove that there wasn't a safe avenue of retreat. We're not going to allow you to put that person in jeopardy of spending the rest of their life in jail. What Stand Your Ground opponents really want, of course, when they argue for repeal of Stand Your Ground, is they want the opposite outcome. They want to say that if a defendant's self-defense claim is perfect in every way, but for the element of retreat, and the prosecutor, who is not, of course, he was not a wholly innocent victim of an imminent life-threatening attack against which he reasonably had to take a human life. If that prosecutor wants to argue to the jury, who also, of course, were not the wholly innocent victims of a life-threatening attack against which they reasonably had to take a human life, if that prosecutor just feels that day like arguing to the jury that the defendant could have run away from the fight, then that defendant being sentenced to life in prison is a just outcome in my eyes. I disagree. I think most of us would disagree. Now, just in a lot of this came up for me recently because I participated in a debate a few days ago at UC Berkeley. They invited me to participate in a Stand Your Ground debate. So kind of the belly of the beast. And I love these opportunities. Sometimes I suspect the reason they keep inviting me to these places is they can't get anyone else who's willing to go. But I'm always willing to go because I believe in confronting people who want to take away or harm our individual rights to be able to defend ourselves. And you have to bring the fight to them because they control so much of the media and so much of the communication channels. If you don't bring the fight to them, we're never heard. So I'm at UC Berkeley to do this debate, and the proposition of the debate was Florida state law may be flawed, but Stand Your Ground is fundamentally sound policy that protects the innocent. So I was on one side, of course I was on the pro side, favoring this proposition, and they assigned me a partner, a Berkeley law professor, who was very pleasant, very nice. It was kind of weird, though, because she actually wasn't on my side. So I was in favor of the proposition. That's our side, in favor of the proposition. She was undecided about the proposition. So it was strange. We actually had three sides in the debate. On the other side, the anti-side, was a CNN legal analyst named Sunny Hostin, who I'll talk about more at length because she became quite interesting, and another law professor who was a very nice person as well. So, of course, why is stand your ground good policy? What was my argument? Well, you've just heard my arguments about why stand your ground is good policy. And then there was the turn to the other side. Why is stand your ground bad policy? And can anybody guess what their argument was? Because it's racist. That's why. So we had a debate, and the debate winner was at Berkeley. Afterwards, one of my opponents, not Sunny Hostin, but the other one, actually came up to me, and she was quite unhappy. She was a law professor at Berkeley, so she lost at home, basically, on something she never imagined would be possible to lose on, because, progressives, they can't really think outside the box. She came up to me and she said, I disagree with you completely, but damn, you were convincing. So, during the debate, something interesting happened. The woman who gave me this backhanded compliment made a statement during the course of the debate. She said at some point, she asked me, she was cross-examining me, as she was supposed to do during the debate. She asked me, on what basis could George Zimmerman have been acquitted, given that he was told by the police not to get out of his car, and he got out of the car anyway? Now, there's a little bit of background. I live blog every second of that trial. I listen to those 911 tapes scores of times. I know that trial better than I know my children's birthdays. I know, because I forget their birthdays. So when she made the statement, I knew immediately that had never happened. So I immediately offered her a wager. I said, I will wager you $100 right now that George Zimmerman was never ordered by the police to stand in this trial. She wouldn't take it back. There was like a long silence. But the CNN legal analyst, Sunny Hostin, who was not physically present, she was participating by Skype, so she was just a big face on the screen behind me. She said, I'll take that bet. But awesome. So, Sunny took the bet. The next day, I emailed her a 911 tape, and which constituted the entire communication between George Zimmerman and the police. So if there was any instruction to him to stay in the car, that's the only place it would be found. Of course, nowhere on that 911 audio does it ever say that he's to stay in his car. So I offered to send her my mailing address so she could make good on her debt. I suggested a $100 bill with her signature on it, to frame it and hang it in my office. But Sunny Hostin refused to pay. You know why she refused to pay? Anybody want to guess? So this was, the progressives keep doing this, and it's so enjoyable because they put themselves in a position where they can't possibly win. I gave a talk recently at a local law school in North Carolina, Campbell Law School. And for the first time in my life, by the way, I had actual protesters, which it was like getting a promotion at work. It was awesome. It was fantastic. And they had begun a tweet campaign to get me uninvited from Campbell Law School and get me uninvited from UC Berkeley. And I just thought to myself, what a foolish strategy, right? I mean, either they're successful or they're not successful. If they're not successful, they lost, right? I got to speak anyway. And if they are successful, I get to crow about how I'm being suppressed by the progressives. It's a win-win for me no matter how it goes. Well, it's the same here. Sunny Hostin, if she had paid me the $100, I might have had one blog post about getting $100 from a progressive company. Man, there's been thousands of tweets everywhere about this. To the point that somebody who was aware of these facts did a downfall parody. I don't know if you all know what Downfall parody is. Downfall is a movie about the final collapse of the Nazi regime. It's all in German, so it has subtitles. But some clever IT person set up a system where you can replace the original subtitles with whatever you want. So it's very common for people to mock their opponents when they make some catastrophic error or have a catastrophic failure to do a downfall parody. You replace the subtitles with things that mock your opponents. Well, someone with knowledge about these events, the debate and the wager and the lulching on the wager, did a downfall parody. So I'm going to see if I can play that for all of you, because I think it's fun. Okay, looks like I have to change a second. It's not too bad. Now, hopefully we won't get any ads popping up. You know, I'm sorry. I have to. Unfortunately, because there's subtitles, I have to be careful that I don't make it. The words won't run off the edge of the screen. Okay, let's try. And hopefully the sound will work.
Von der Branca-Formation zu besprechen. Im Süden hat er gegen Zossen genommen und stößt auf Starnzer vor. Von liegt der Kontinentenstadtfront zwischen Frohnau und Pankow. Und im Osten ist der Feind bis zur Linie Lichtenberg, Marsdorf, Karlshaus gelangt. Mit dem Angriff scheint das. Mit das alles in Ordnung. Mein Führer. Steiner konnte nicht genügend Kräfte für einen Angriff massieren.
Jodel, Krebs und Butter.
Das war ein Befehl! Der Angriff Steiners war ein Befehl! Wer schickt sie?
Dass die Soldaten, die für sie verpflichtet sind, Feindlinge, Verräter, Versager! Mein Führer, was Sie da sagen, ist ungeheuerlich.
Die Generalität ist das Stolz des deutschen Volkes. Sie ist ohne Ehre. Sie nennen sich Generale, weil sie Jahre Militärakademie Ich hatte gut daran getan, von darin alle Höheroffiziere registriert zu lassen, wie Stalin! Ich war nie auf einer Akademie. Und doch habe ich allein aus Business Welt, ganz Europa erobert. Verräter! Von Anfang an bin ich so verraten und betrogen worden. Es wurde ein ungeheurer Verrat geübt am deutschen Volk. Ich soll bezahlen. Mit ihrem eigenen Blut werden sie bezahlen. Sie wird das Saufen in ihrem eigenen Blut.
book, Law of Self-Defense. We do Law of Self-Defense seminars. You get the idea. I guess after we talk, we'll have a panel opportunity. Is that how that works with questions? So I'll stay up here, and if the next speaker is completed, if anyone has questions, I'll